Home Affairs and Law Minister says Lee Hsien Yang and his wife, Lee Suet Fern, were named while under investigation as the discussions surrounding 38 Oxley Road are of significant public interest. Mr. Shanmugam said the couple had given dishonest evidence under oath and had essentially absconded from jurisdiction. Mr. Shanmugam was responding to questions from opposition MPs on why the pair were named, while executives of the Keppel O&M bribery case were not.
The police have disclosed their investigations when there is some public interest involved and when the people and the facts of the offences under probe are already publicly known. An example, as cited by Home Affairs and Law Minister Lee Shanmugam, is the case of Carl Liu, of whom the High Court said had given false evidence while under oath during a case involving his family's former helper, Pati Liani.
The reasons for disclosing that Mr. Lee Hsien Yang and Mrs. Lee Suet Fern were under investigation are broadly similar to the reasons why it was disclosed that Mr. Carl Liu was being investigated for perjury, except that in the case of Mr. Lee Hsien Yang and Mrs. Lee Suet Fern, they have in addition absconded from jurisdiction. In Mr. Carl Liu's case, we were discussing his conduct and the conduct of other family members and the court's findings in this House. We thought it necessary to disclose in that context that Mr. Carl Liu was being investigated.
Mr. Shanmugam also addressed questions surrounding measures to ensure that public disclosure doesn't prejudice the investigation or the individuals concerned.
When a disciplinary tribunal says that a person is guilty, it can only do so if it is satisfied beyond reasonable doubt on the guilt. Likewise, a court of 3 judges in disciplinary proceedings. The statements in Parliament about Mr. Lee Hsien Yang and Mrs. Lee Suet Fern do not materially add to any clout the couple may already be under based on what the tribunal and the court of 3 judges have said. If the facts are different, then the position will be different.
Turning to the Keppel O&M case, Mr. Shanmugam explained that the Corrupt Practices Investigation Bureau and the Attorney General's chambers concluded they couldn't sustain any charges in court. That's because the alleged errant conduct happened overseas, and as such, key witnesses and documents are unavailable.
The CPIB, for good reasons, has the reputation for being able to ferret out the truth. But even the CPIB can't get something out or proceed with charges when there are no documents or other evidence which cross the evidential threshold and which can be used to break down the interviewee's defenses. In these circumstances, the general policy of not disclosing the names of individuals who have been under investigation applies.
Meanwhile, other examples of when people under probe may be named include when the police have to make public accurate facts to dispel falsehoods about a case, for instance.
Double standards and due process were areas opposition MPs raised questions over regarding the public disclosure of the probe into Lee Hsien Yang and his wife. Non-constituency MP Hazel Phua, for one, asked Mr. Shanmugam on the timing of the release of the information.
There is much chatter that the investigation and the timing of the release of this information is linked to the interview with Bloomberg, where Mr. Lee Hsien Yang actually said that he might consider running for president. So would the minister like to clarify on the situation?
My recollection is that the Bloomberg interview came after the answer given by Senior Minister Teo. And therefore, even the prescience of this government could not have foretold that Mr. Lee Hsien Yang was going to give such an interview. I stand corrected, but that's my recollection of the sequence of events.
Lee Hsien Yang and his wife were named, and the police probe made public in a written reply to Senior Minister Teo Chee Hean to a parliamentary question earlier this month. A Workers' Party MP, Leon Pereira, had questions on possible prejudice from the disclosures as well.
What are the safeguards put in place to make sure that that disclosure into the public domain does not prejudice in some way the conduct of due process, a subsequent trial, and so on that may happen later on?
sometimes public interest may require disclosure, even if it means some degree of prejudice. So that's an assessment, and it's an assessment we have to make. In this case, in the case of the lease, I have explained why I think the prejudice is pretty much non-existent, because we are simply repeating what has been said and saying that the police are investigating that matter, which everyone would expect us to do anyway.
And Workers' Party MP Sylvia Lim also had a question on whether the police had actually issued an order to Mr. Lee Hsien Yang and his wife to attend an interview.
And his answer was that they were emailed and they said that they would cooperate. So do I read from that actually the police had not gotten to the stage when an order under the CPC, Criminal Procedure Code, was actually issued to them?
That is right, sir. So a specific order under the CPC was not issued. The police normally would not issue such an order. They would first contact and speak with and send a written document. And if a party says that they will cooperate, the police would assume in good faith that that's how they will proceed.